Welcome to Employee Benefit Plans and Business Sense.
Hello and welcome back to Employee Benefit Plans and Business Sense with Lank and Kathleen Salas Bass of KLB Benefits Law Group. And Kathleen help employees and benefit plan service providers navigate the complex legal requirements of employee benefit plans. With decades of combined experience in employee benefits law, they guide clients through compliance matters, corrections, and IRS and DOL audits. I'm Lisa Mosby, and today we're talking about retirement plan qualification failures and how they happen and the different ways employers can correct them. Welcome, Kathleen. Welcome, Dal. Thank you for joining me today.
Thank you. Oh, it's a pleasure to be here.
Kathleen, let's start with what is a retirement plan qualification failure? Can you give us an example?
Sure thing. Well, a retirement plan, as most people know, there's a benefit, a tax benefit, usually something like, the plan has, deferred taxes you don't pay until you start taking distributions from the retirement plan. But that ability to defer those taxes is sort of dependent upon following the rules. And a plan qualification failure, as you might imagine, is some failure that jeopardizes the tax qualification status of the plan. And they basically come in two flavors. The first one is an operational failure. And basically what that means is the plan provisions are all correct, but in administration of the plan, some mistake or some failure happens where the plan is administered contrary to the terms of the plan. And a specific example would be like a failure to offer an eligible employee the opportunity to participate in the plan, or the failure to start taking deferrals once the eligible employee actually makes an election to participate in the plan and start making deferrals, or using the wrong definition of compensation. There's lots of ways that an operational failure can happen, and they do frequently. The other type of plan qualification failure is a plan document failure. And basically that's where there's a failure to adopt a legally required amendment or complete restatement of the plan, or even like a failure to adopt a timely amendment for a discretionary change to the plan. So those can also jeopardize the tax qualification of the plan.
And what happens if a qualification failure isn't corrected? And I have a second question with that, and that is, can they always be corrected?
So to answer your second question first, yes, they can always be corrected in some form. And what happens is, an employer who doesn't correct a failure and they know about it, they're really not, they're playing sort of a game. We call it audit roulette. And what that means is that if it's not corrected when they find out about the problem, it's likely that it will need to be corrected down the road. For example, if they get audited by the IRS, which that is sort of, who knows if they will be or when they will be. If they are a large enough plan or become a large enough plan that they are required to have an annual audit by an independent auditor as part of their Form 5500 filing, well, those auditors are thorough and they will most likely find any failures. And then sometimes even employees will, figure out that there's been some mistake made, and, they might bring it to the attention of their employer, requiring some kind of, big correction. And, there might even be a lawsuit where this is sort of brought up and revealed. And the problem with correcting a failure down the road rather than right when you find out about it is that it costs more if you don't correct it earlier. You save money by correcting it earlier. And, obviously, if you wait years to correct something, then you have years of earnings that have to be paid on those corrections. More earnings have to be paid. Also, if it's corrected because of an IRS audit, there are going to be sanctions which can be quite expensive. And then, similarly, if the correction involves the payment of excise taxes, those just kind of balloon over time. So, you always want to make sure that you catch your excise tax off as soon as you can. The other consequence could also be for some failures that are significant and that happen over a long period of time, you might lose your ability to self-correct, and then you have to go through the what we're going to talk about, I'm sure, is the VCP process, which is more expensive.
And then, Kathleen, what are the options for fixing a failure?
Well, with regards to qualification failures, the IRS has a correction program, and they issue a revenue procedure every so many years with all of the requirements of this correction program. It's called EPCRS, stands for Employee Plans Compliance Resolution System, and EPCRS has three correction programs within it. One is a self correction, the ability for an employer to just fix it themselves, not themselves. They have to have other people help them, but it's just sort of like you don't have to get the IRS involved with the self correction. And that program's called SCP, Self Correction Program. Then there's another program where it's for voluntary correction with IRS approval, and that's VCP, Voluntary Correction Program. And those are the either the programs in which you go into the IRS, or at least the program that guides you on how to fix under self-correction.
And I want to dive a little bit deeper into that VCP. That sounds like the one that that people often use, maybe the most, and I could be guessing on that. But can you tell us what submission requires for VCP?
Oh, of course. And actually, let me just correct you there. Self-correction actually happens more often than this voluntary correction with IRS approval. And basically, and that's kind of by design, the IRS is sort of encouraging people more and more to self-correct. So they're making their self-correction program a little easier and broader for people to self-correct things. But sometimes a VCP just is required. I mean, it's the only option. So basically, what a submission requires is that a submission be prepared, and a VCP submission will include a description of what the failures are. They'll include what the proposed correction is, and that includes the amounts of the correction and what method you're using to come up with those numbers. And if it's not one of the pre-approved corrections that are described in that EPCRS revenue procedure, then you have to justify that. You have to give an explanation of why this special proposed correction is justified and reasonable. And so, that can take a lot of work there. And then also what method is being used for calculating the earnings on any correction amounts. For example, the IRS's favorite is actual rate of return for the participant. You go and look at what they actually elected to invest in and what the returns were, and you use that. There are also other methods like the DOL has an online calculator that the IRS generally accepts, in particular if there's no actual rate of return information available. And the other sort of information that you have to have in this submission is you have to describe the changes to the administrative procedures that the plan sponsor has implemented in order to make sure these kinds of mistakes don't happen again. And if there are participants who are affected by the correction who are no longer employed by the employer, how you're going to go and find them. And the other thing a VCP submission sometimes requires, actually quite frequently, is once you've done the submission and it gets assigned to an IRS reviewer, negotiation with the IRS reviewer about, how this is going to be corrected is very often a requirement necessary, to get that approval by the IRS.
Yeah, and I just wanted to add that this is a juncture where the VCP is a place where the ERISA attorney can really advocate and save the client a lot of money in a correction.
Yeah, I mean, I think that in my experience, Doll's exactly spot on, is that a lot of times when you decide to go in with a VCP submission, it's because you don't want to just do the expensive correction that might be required under self-correction, the EPCRS correction method. So a lot of times you have to go in and you have to, provide documents that sort of support the reasoning that you're proposing. And a lot of times the IRS reviewer may not be comfortable with that. And so you kind of have to, reassure them and convince them and, stress different things. So that's sort of that. It's not all just done in writing. A lot of times it's done, in consultation, in conference with the IRS reviewer.
Sure. And then what are the pros and cons of self-correcting versus correcting through VCP?
Good question. And that relates to your earlier guess about which one is more popular. The SCP is less expensive generally because you're not having the cost of preparing that submission. You're not having, which could involve costs to a third party administrator to do calculations. And it definitely, costs to an attorney to, review it and submit it for you. And there's also a user fee that is involved with a VCP. So the self correction is less expensive because it doesn't have those costs. But I would say, sort of, if you're going to do self correction, you really have to stick with those safe harbor corrections that are listed in that revenue procedure, and because you're not going to get IRS approval, so you kind of have to stick with that revenue procedure and say, and think of it in terms of those are pre-approved by the IRS because they're in that revenue procedure. So if you're not going to, actually get an IRS approval on it, you need to stick with the safe harbor. A VCP sometimes can offer more flexibility in the correction method within reason, though. The IRS is getting less and less staffing, and so they're kind of discouraging VCPs, and because they don't have the staff to review them. VCPs often take a long time for that reason. I mean, it can take like a year to actually get a reviewer assigned to a complex VCP submission. But the good thing about a VCP submission is that you end up having the IRS's approval at the end of it. Now, there's sort of like another negative there, which is when you go in under VCP, you're now putting IRS eyes on it. They know that you have this failure, and by the end of the process, you're going to have to resolve it one way or the other. You no longer have the option of not correcting. And so, VCP can be more expensive. It takes a long time, and, there's a certain vulnerability. I will say, though, that I have usually found IRS reviewers to be pretty reasonable when dealing with them, but with this lack of full staffing, they're also being less willing and less able to do much more than sort of those safe harbor corrections. So once again, it's like you might as well go with self correction in that situation. So it's sort of a mixed bag, and it really depends on the situation. If it's a really complicated situation with a lot of failures, it might be just worth it to go into the VCP. Also, self-correction, when it's a significant failure, it may be something that there's a limited time during which you can actually self-correct. And if you go longer than that before you correct, then you end up having to do a VCP if you want to correct it.
And Kathleen, what if an employer can't afford to correct a qualification failure?
Well, that is a situation that we run into a lot. And if there's actually a financial hardship with the business, sometimes the IRS will take that into account and reduce the correction amount. But it has to be something that can be backed up with documentation that the business is actually having a hardship financially. And ultimately, it's a business decision by the plan sponsor to decide whether they're going to correct, and they're going to take chances with a potential audit and having to pay more down the road, or how much they're going to correct. um, Generally, it's always the best practice is to always correct it, at least in some fashion, and as soon as possible.
And what happens if the retirement plan is audited by the IRS before the failure is fully corrected?
Yikes, right?
I think so.
Well, I mean, if it's an insignificant failure, it can be self-corrected at any time, including if the plan is under audit. That's fine. Um, and if there has been a VCP filed, one of the benefits of VCP is you get audit protection on the failures the moment you submit it to the IRS. So even if um, you know it hasn't been approved yet, hasn't even been assigned to a reviewer, whatever, it's in process, um, or even if it's been approved, but then you kind of have like a deadline. Once it's been approved by the IRS, you have a deadline to carry out all the corrections. But as long as that deadline hasn't passed, then you've got that audit protection. But if neither of those two situations are the case, then you basically have you're now in audit cap, which is the correction under audit that is also under EPCRS, but that's where you're going to have to correct it, and usually without much negotiation. Plus, there are sanctions that also can be levied that can be very expensive. Again, this is where the lawyer comes in and can maybe negotiate those sanctions down a bit if there are situations that support, good faith or something like that. But it's kind of like once you get notice that your plan is under audit, you're kind of stuck.
Kathleen, do you have any final thoughts for our audience on if they're in this situation, what steps should they be taking today?
Well, if they are aware of a plan failure, a qualification failure, um, fix it. And that means working with their third party administrator to figure out the scope of what the correction needs to be, costs of the correction, and then work with a lawyer. Even if you're doing self correction, and you don't need that lawyer to go into the IRS for you. A lawyer can help guide the third party administrator and the plan sponsor to properly correct at the minimum amount necessary to meet the self correction principles, and to document it so that if something happens down the road, an audit or something, there's documentation showing that it was corrected, how it was corrected, which at the very least represents good faith on the part of the plan sponsor that they tried their best to fix it.
In my experience, third-party administrators tend to accompany their annual reporting process with a letter to the plan sponsor describing any issues they've identified, compliance issues, and they'll spot qualification failures and list them and describe them. And I've known so many clients who fail to even open that email or read it or think about what that third party administrator is saying to them. And that, as Kathleen said earlier, time is money when it comes to correction. So if your third party administrator sends you an email, you should read it and understand what they're
Yeah,
saying to
always.
you.
You should always read. You listen to your third party administrator. Always read all the documents that they send you.
Truly. And the other thing is that when people will catch failures sometimes when they're terminating a plan, you have to review it and make sure that all the failures have been corrected in order to terminate it. You're not allowed to terminate a disqualified plan or a plan that's arguably disqualified, you can't just fix it by terminating the plan without fixing it. You have to fix it with money, the corrections.
It
And
can still be audited.
yeah, and so people will sort of collect. They seems to me a lot of plan sponsors collect communications from their TPAs without really reading them, and then when they come to terminate the plan, the TPA says, "Well, remember all those failures we pointed out? You can't terminate until they're fixed, and they might go back years. So you can't, like, kicking the can down the road is not an option."
Mm-mm. All right. Well, we'll leave it there, ladies. Thank you so much for your guidance and walking us through this process.
Thank you, Lisa.
Folks, thank you for listening to Employee Benefit Plans and Business Sense. If your organization is dealing with a retirement plan qualification failure or trying to understand the best way to correct one, visit klblawgroup.com to connect with Dahl and Kathleen. Be sure to like, leave a review, and subscribe. We'll see you next time. Come on back.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.